Hello, everyone. Welcome back to another episode of the Divorce Differently podcast. Now, today's episode is about a situation that I see time and time again, trying to live under the same roof while going through a divorce. Now, for financial and practical reasons, for many people, they feel like they have to stay put until everything's finalized. But emotionally and day to day, that can quickly become incredibly difficult. And I remember that was the case in my divorce. So, in this episode, I want to explore what your options are when cohabitation simply isn't possible anymore. Whether you can't afford to leave the house or your spouse is refusing to, what is the support and what are the pathways that exist when staying in the same house becomes unsustainable? So, to talk about this, I've invited Emma Post. Emma is the co-founder of Any Family Law, a resolution accredited specialist family solicitor in complex financial remedies and private law children cases. Emma is also a resolution all issues trained mediator and an advanced hybrid mediator, helping individuals and couples to navigate separation and divorce. Emma, thank you so much for joining me today. It's great to have you.
Thank you for having me.
So I mentioned a few examples, but I'm sure you've come across many, many situations where people are effectively forced to cohabitate, and it becomes very difficult during those tense months of the divorce process. So why, in your experience, is it not always the best option to stay in the same home when there's a lot of tension?
Well, I think first of all, one of the things that often comes up is that people are at different places at different times. So you've often got perhaps one party that's made that decision to end the relationship, and the other person is playing catch up, and that
Yeah,
puts them immediately on a different playing field in terms of where they are emotionally, practically, what they're thinking about, and often because perhaps one person has made that decision earlier on and has processed it for themselves, the other
yeah,
person isn't given any time to catch up, to
yeah,
breathe, and just to take a moment to reflect and find their feet with it all. And that can then sort of propel itself and springboard into difficulties with remaining in the same house,
hmm,
because there is increased conflict. There's people being emotionally in different places. There's high stress, and high stress increases conflict. Children are there, they're exposed to it, and it puts a lot of pressure on couples to
yeah.
either make decisions they're not ready to make, or dig down and not be able to move themselves forward. So I think that's one of the main things I think that drives this is that sort of the difference in readiness to move
Yeah.
things forward.
Yeah, I also see people complaining a lot about or just commenting on the fact that they feel that the tension has an impact on their children, and that's usually the driver. I mean, sometimes it's just a sense of wanting their own space, and they want that physical representation of the state they're at in their minds. But
Mm.
with the children caught in the middle, it can also create a lot of tension, can't it?
It absolutely can, and I think what it also then heightens is that sort of need to settle those arrangements more quickly
Hmm.
because they're all in the
Yeah.
same house, and so there becomes this tension between what was normal before the separation
Yeah.
became apparent, and then what is the new normal and how that needs to look. And for children, that's very confusing because in their minds, their parents are still in the same house, but things are
Yes.
different on the ground, and often one parent will want to perhaps drive a change in those arrangements much sooner, even though they're still in the same house, in order to get
Yes.
that sense of separation and that sense of independence with what's
Yeah.
happening. And I think that really, children then inadvertently become pawns in that process because they're just being pulled from pillar to post without necessarily parents wanting that or that being the intention, but that is the reality of being in the same house, and those tensions get rising.
Yeah, and you raise a good point actually, because for a lot of people, staying in the same house is inevitable from a logistical perspective, and but they want to put in place some interim measures
Mhm.
and some agreements for how things are going to happen or be operate during that period of time. And in France, for example, that's one of the first things that happens when a couple files for divorce. The very first thing that happens is a hearing to decide on what happens financially and living wise with regards to the children during that period that the
Mhm.
divorce is going to require to finalize. In England, we don't have that. And that's always a bit of a struggle because you want to talk about the big picture. People want to focus on their long-term arrangements, but sometimes they do need to resolve immediate issues as well,
Mhm.
don't they?
Mm, absolutely. And because we don't have that process here where there's that natural next step that you go to a court and you sort out those interim arrangements, often, I'm often talking to my clients about go to me thinking about mediation, even if it is only for those interim arrangements, the
Yeah.
practicalities of separation, what that means if you've got to remain in the same property, how that's going to impact your child arrangements, and how you can set those boundaries to make this period of time as to navigate it as best as possible, whether that's the interim financial arrangements, what those interim child arrangements might look like, and enabling you both to have a period of time away from the family home, perhaps just for short periods, to give yourself some breathing space and some time away. And there's some practical things that go to that as well, in terms of whether or not, if you're remaining in the same property, whether it's practical to live to be in separate bedrooms, to share spaces differently, to think practically about how best you can navigate being in the same property, but trying to live as independently as possible if that's what you need right now. And because we don't have that sort of natural legal step that you have in France, something like mediation can be really, really effective in just opening those discussions up and getting something which helps the longer term discussions take place at the time when you're sort of emotionally ready, because you've got something in the interim that is going to work as best it can.
I agree. Yeah, because I think actually when you're having very tense conversations and negotiations, and on top of that, you're arguing every day at home, it just makes that much more tension and conflict into the conversations. It's just sometimes it's actually not an advantage for anybody to have that kind of environment.
No, and actually that leads into sort of thinking about how best to communicate when you're living under the same roof as well, and thinking about not having big conversations in first thing in the morning or last thing at night, or limiting your discussions. If you need to talk about something, make it a single issue, so that you're having a chat about that thing before it blows up into a number of other things that you're not ready to talk about, and set that time aside. And I often say to my clients, or for couples I'm working with in mediation, if you need to have those discussions, perhaps take it outside of home, go for a walk, go and sit in the park, do it away from that, your home environment, and certainly obviously when the children aren't there. But that can really help, just trying to focus those discussions a bit more and be a bit more constructive.
I agree. So a lot of people in that context, because they find these conversations difficult and the situation is incredibly tense, they ask what the law says and how would the law decide who stays in the home. And the obvious question is, can I kick out my spouse? And sometimes it is, can I leave? And what are the knock-on effects of my walking out? So what does the law look at when they're deciding who's going to stay in the home?
So what the law is looking at, it first and foremost is the family home. So the family home is the centre point often for many, many, many families. And no interim decisions are going to impact the long-term outcomes, is the first thing to say. So sometimes it is necessary for one person to move out, whether that's by choice or because safety dictates that there needs to be protective orders in place, which we're going to have a chat about. But if that happens, that doesn't impact the long-term entitlements to the family home. Making a decision to leave for your own well-being or the well-being of your children, or vice versa, doesn't shift that starting point. But what the court is looking at is whether or is really first and foremost the children and what the children need and what's right for them. It's looking at how the future housing needs can be met, or the interim housing needs can be met, and what the financial resources are to do that. And that is the starting point. Whether the family home is registered in one spouse's name or in joint names doesn't impact that either. And there are ways of making sure that you can protect your rights moving forward, whilst you sort out the longer term arrangements for what's going to happen with the house.
Yeah, so maybe can we touch on that a little bit? Because people are often concerned about their rights, especially if they're the one leaving the house. How can you establish home rights without having a negative impact on anything relating to the divorce?
Sure. So, if you're joint owners of a property, then that's the position in law. You've automatically got your home rights. If the property is owned just by one spouse, then what is generally advisable is that you register something called a home rights notice. It's a form that you send to the land registry. It's a very straightforward form and there's no fee attached to it. But what it's really important for is it establishes your rights of occupation. It protects your rights of occupation as a non-owning spouse. It prevents the sale or disposal of the property without you knowing about it. Essentially puts a buyer on notice that there's a non-owning spouse with occupation rights. So it helps just hold the ring. and
Okay.
stops anything from happening, and is a really important step, particularly in circumstances where perhaps you're separating and leaving the family home and you're a non-owning spouse or
Yeah.
civil partner, I should say, applies to spouses or civil partners.
Hmm.
That home rights notice, once it's registered, stays in place
Okay.
until a triggering event. And usually that would be a final order in a divorce or civil partnership dissolution,
Hmm.
an order of the court, the written agreement between you because you've reached an agreement on your finances,
Yeah.
or the death of one party. It would generally
Okay.
see itself through. So it holds that ring right until the end.
And should people be doing it preventively, or is it something that's only necessary at the time of divorce?
Only on the point of separation is generally when
Okay.
you would do it. You wouldn't need it in place prior to that because the risks would be low. So it would be
Okay.
something to certainly to take advice on in the event that you're separating, and to do that as soon as possible.
And how long does it take to actually get it once you submit the paperwork?
So it does depend. They can take a little bit of time. They can come around very quickly, but they are supposed to be prioritised at the land registry. But we're slightly out of our hands. But I would say they're normally done within a matter of weeks.
Okay, so that's fairly fast. Okay, so it gives people that security and that comfort that
Yeah.
their rights with regards to the home are not going to be affected by whatever they do. So staying on that kind of legal track, there are times, and I've had a lot of clients where they know cohabitation isn't working. My client can't afford to move out, but they really want the other person to leave. What are the legal recourses with regards to various orders that they could obtain? Maybe we'll talk about non-molestation orders, and then we can talk about occupational orders. Could you talk us through what those orders are, how you get them, and especially what effects they have?
Sure. No. So a non-molestation order is a type of protective order that's made under the Family Law Act 1996. To be able to make an application for non-molestation order, which effectively prevents the other person from violent or threatening behaviour, pestering behaviour, harassment. It can regulate how you communicate between you. It is you do have to be an associated person in order to bring an application for non-molestation order, which means you need to be a spouse or civil partner, you need to have
Hmm.
cohabited, or in some circumstances relatives, and engaged couples would also be associated persons. And
Okay.
that application is an application that's made to the court, and it can be made without notice. So
Okay.
that's asking the court to make an order without putting the other person on notice that that's going
Hmm.
to be heard, or it can be made at a hearing where both parties have a chance to be heard and to tell their side before a
Okay.
decision is made. It is an interim. It is an interim measure, so it isn't intended to last forever.
Okay.
And any application that's made for non-molestation order has to be supported by written evidence. And
Okay.
typically that would mean setting out the background to your relationship. And usually what gives rise to non-molestation order is behaviour that
Hmm.
requires protection,
Yeah.
that the courts needs to step in to stop the behaviour happening and being perpetrated by one person against the other, and the impact of any children. So it needs to be supported by very clear written evidence about the behavioural patterns of behaviour that person is suffering. It doesn't need to be physical violence. It's not limited to physical violence. It covers
I was going to
all
ask you.
types
Yeah.
of domestic abuse,
Psychological control, all that would be,
psychological,
yeah.
coercive, controlling behaviour, psychological behaviour, economic or financial
Hmm.
abuse. It covers the whole spectrum of the types of domestic abuse that fall under the Domestic Abuse Act.
Okay. And so once you request, I guess, first of all, how high is that bar? How bad, I guess, does it need to be for the courts to give you a non-molestation order?
So it's subjective to some degree because it's obviously your lived experience and the behaviours that you're suffering, but you do have to meet the bar of being an associated person and being able to explain the behaviour that you're experiencing and the impact that it's having on you and your well-being and your fear for your safety. The bar for non-molestation order, the court has to be satisfied that on balance, an order is required in order to protect you and that there's no other avenue being explored that would give you that protection. For instance, if some behaviour gives rise to a criminal sanction and there are ongoing proceedings or bail conditions, and the court might consider that a non-molestation order isn't necessary in those circumstances because you're being otherwise protected by another path. But absent that being in place, if the court is satisfied that the behaviour is such and the impact upon you requires the court's intervention, then an order will be made. The bar perhaps is different if you apply without notice as opposed to being on notice, because on a without notice application, you're asking the court to balance the need to make that order for you without hearing the other person share their views. And so the court has to be satisfied that it is sufficiently serious and that protective order is needed immediately and without that notice, and that you are further protected by having the notice, perhaps because you are concerned that you would be persuaded from withdrawing your application if there was a period of time between making the application and actually the hearing taking place. Or that there would be an escalation in the behaviour that puts you at a greater risk. So the court has to carefully balance that when considering whether or not to make an application to make an order without notice. But often, even if they do that, there would be a return date very quickly within a couple of weeks to hear what the other person has to say about it before the order is considered as to whether it should continue. So the bar on the non-molestation order by comparison to perhaps an occupation order, which we're going to talk about, is lower because the types of behaviour that it captures and the protective nature of the order is slightly different.
And does it apply to the children as well, or does it only protect the spouse who's applying?
Ordinarily, it would apply to both. So you can apply in your own right as a spouse, but you can also apply for it to apply to children as well. And what often you see out of these orders is if there are children, it will generically apply to both, but there might be some caveats within the order that enables you to communicate, for instance, purely in relation to arrangements for the children or via solicitors for the arrangements for the children. But it often would cover both in circumstances where there are also children in the home.
And so how long does it usually take to go through this process and to get the order?
So an application that's made has to be dealt with very urgently by the court, particularly if it's made with notice. Under the new guidance that came out at the beginning of this year, an application that's filed on the day before 4 o'clock should be heard, if possible, or referred to a judge within that day or within 24 hours.
Oh, wow. So it's very quick.
It can be very quick. And if a hearing is then listed on notice, it's often listed on short notice in order to get everyone there as soon as possible.
That makes sense. And so what is the full effect of having a non-molestation order? What does that mean the other person can't do or you have to do potentially?
So generally speaking, it would prevent your spouse or ex-spouse using threatening behaviour, violence, pestering. So that can be by way of, text messages or bombarding you with emails or phone calls. It also prevents them encouraging a third party to do those behaviours against you, so as a conduit. A non-molestation order can be zonal in nature, so it can regulate the use of the family home or prohibit somebody coming within a certain distance. There's a zonal element to a non-molestation order. And it's a serious order that, if breached, is a contempt of court. It has a power of arrest attached to it. So if the person against whom the order is made breaches that order, it has very serious consequences.
So when you say it prevents them, it means that, it doesn't physically prevent them, but if they were to do it, they would then be in trouble with the law.
Yes, absolutely. Sorry, yes.
That's helpful to understand. So you mentioned it, and I think I mentioned earlier, the option of an occupational order. Could you tell us a little bit more about those and when one would apply versus the other?
Yeah, sure. So an occupation order is, when compared to a non-molestation order, is considered a more draconian order to be asking the court to make. What you're asking the court to do is exclude somebody from a property of which they either have occupation rights or that they live in and have access to or legal rights to. So it is a very serious order for the court to be making. But generally speaking, what an occupation order will do is it will determine who can live in or access a property. It can make declarations about how a property should be lived in, and it enforce rights of occupation. So if somebody is being excluded from their property, it can have the effect of saying you are allowed to live here. So it can do the reverse. It can also be zonal in nature. So you can have an occupation order that doesn't exclude somebody from being in a property, but regulates how the space is used. So dividing upstairs and downstairs depending on the layout of the house. And often when you make applications for an occupation order, it's really helpful for the court to have a map, a sort of plan of the property itself, so that they can see what the practical living arrangements are, whose bedrooms are where, what the shared space is, so that if an occupation order excluding somebody isn't an option for and we'll talk about the test that applies, it may be that there can be some regulation to the use of the family home to help diffuse those tensions and give that protection in a slightly different way. There are some financial elements to an occupation order as well. So the court can also make orders about who should pay interim expenses, such as mortgages and outgoings and repairs and maintenance for the duration of the order being in place. And again, none of these orders dictate what the ultimate outcome is going to be in relation to the family home. These are just temporary protective orders in place to bridge a gap whilst the long arrangements are made. The test for an occupation order is slightly different to that of non-molestation order. What the court is looking at is what are the housing needs and resources of both of the parties, and what are the needs of children within that context. It's looking at the financial resources generally of both parties. So is there a disparity in income that would perhaps enable one person to be able to rent on a temporary basis, for argument's sake, that would mean that the occupation order could be put into place without adversely affecting anybody? And it has to look at what the impact of making the order is against the person whom the order would be made against, but also the impact of not making that order, applying for it. And that's the balance of harm test, which is the crux of whether or not the court is satisfied that that bar, and it is a high bar for an occupation order, is reached. Is there a risk of significant harm to either the person applying or a child of the family? And unless the other person or the child won't suffer greater than if the order is not put in place, that's what the court is grappling with. And I hope I've explained that properly, because the balance of this is
it's a difficult balance.
You are balancing the harm somebody is alleging they're at risk of, and the harm against what the person that's impacted by the making of that order, and which is greater, essentially. And if the court is satisfied that the harm is significant, they have to make an order. If they haven't reached that bar, that it then falls to that balancing test, and the court then has a discretion as to whether or not an order is made. It certainly won't be made indefinitely. It's usually for a specified period of time, or until it's often linked to any financial remedy proceedings. So when those are brought to a close, or there's often linked in that way.
So I've seen occupation orders used in one of two ways, and maybe there's other ways. Let me know. Either for somebody who'd been actually evicted or kicked out of the house by their spouse to reclaim those rights and be allowed back in the house, or to exclude the other person from the house because they felt that they couldn't be cohabitating. Are there any other scenarios where someone would require an occupation order?
They are the main two. The other main one would be to regulate the internal workings of the family home, which is what I was talking about in terms of not necessarily that you want to kick someone out. It might not be practically possible, but you cannot live in the space as you are, and you can't otherwise agree how you're going to live, and there needs to be some protection to that, or some mechanism in place in order to be able to regulate that in the interim, to make sure that everybody is able to live as peacefully as possible. Would generally be the other main type of order that's used.
And you mentioned that's also a feature in a non-mol order. So do people often apply for both at once, or would you choose one of the two? How does that usually work?
They generally, I would say generally it's either a non-molestation order or it's both. If it is linked to a concern that there is a risk of significant harm, you would ordinarily, because the bar is so high on an occupation order, you have to assess the merits of that application quite carefully, and it is different to a non-molestation order. So they do often go hand in hand when an occupation order is needed, but you often see a non-molestation order
Yeah.
As a standalone application, then I would generally be thinking about then whether or not some sort of zonal element to that would be appropriate, which doesn't means you can satisfy the court of getting that order and that zonal element without necessarily having to cross the bar of an occupation order.
Yeah.
But it's very case specific in that sense. You have to think about what's going to work for the circumstances of that case.
Yeah, that makes sense. And so in that context, there's a question that's springing to mind because a lot of my clients actually ask me this, and I refer them to a lawyer, of course, because they often wonder whether they can change the locks on the other person. So they're going up, while they're at work or on wherever, can I go ahead and change the lock and physically prevent them from entering the house? Where does the law stand on that?
So a joint owner has a right of occupation. So absent them being excluded from the property by way of a court order, generally speaking, changing the locks is going to heighten the tensions, not dispel them.
Yes.
And because, as an owning spouse, you have a right to have occupation of your property unless you're being excluded by
Yeah.
way of an order or the law. So generally speaking, it isn't advisable. And if you are, if anybody was worried about their safety, then there are other avenues you should consider
Yeah.
before.
And so you mentioned the non-molestation orders don't have a cost associated with them. Do occupation orders have a cost?
Not to make the application, no, but
Okay.
obviously, depending on whether or not you're making the application through solicitors, or whether you would meet the criteria for legal aid, would
Yeah.
depend on then whether you have other costs associated with the applications. But there's
Yeah,
no
that makes sense. So we talked about the legal avenues. Are there any other options for people who want to legally enforce their rights or remove the other person from the house?
Um, so the only other way that you would be able to think about doing it is by reaching agreements
Yeah.
and having deeds, perhaps an interim deed of separation, which sort of touches back on what we were talking about at the beginning, which is about thinking about what the interim arrangements should look like. So part of that
Yeah.
could be having a temporary separation deed in place, which regulates how you're going to live in the family home or not. And what the financial arrangements that are going to flow from that are going
Yeah.
to be. That is an option that would be available, and it is a really effective mechanism if you think that there's going to take a bit of time to sort
Yeah.
the bigger picture out. It can be a really good way of getting everybody on the same page
Yeah.
in terms of how it's all going to look, and give some reassurance as well, because I think people do worry, that they can't live in the same property together, but they don't want to leave in case that means they lose their rights or
Yes.
it impacts their future. And so something like a separation deed can really help with that. Another thing that is becoming a bit more common than it used to be is a nesting arrangement.
Yeah.
It is another way that we're seeing couples deal with it. And a nesting arrangement, or bird nesting as it's otherwise called, is where you essentially keep the children in the family home. But you rotate their care by one parent generally moving out for a period of time. The other
Yeah.
parent will take the care of the children, and they swap over, and however those arrangements might work on the ground for them. And that can be the other person, that can be renting a separate property, for instance,
Yeah.
that both parents are then using on rotation, or staying with friends and family if it's for shorter periods of time, or in circumstances where perhaps there's other arrangements that can be put in place. Nesting, it is becoming more common. I get asked questions about nesting all the time, and
Me
people
too.
often have the arrangements in place. And I think it can be a really effective short-term solution for parties whilst they transition into what the future is going to look like. But I do think it is short-term.
I agree.
I think there are a number of considerations that have to be borne in mind when you're thinking about a nesting arrangement, and this sort of leads back to the sort of interim separation deed, perhaps, because
Yeah.
you do have to think about the finances. Who's going to meet the mortgage payments? How are rental payments going to be met? How are the outgoings for both those properties going to be met? How are the kids' costs and arrangements going to be? Who's buying the food for which property at what particular time? And it's those sorts of minor details that make the bigger things unravel, aren't they?
Absolutely.
Who's cleaning? Who's cleaning the family home? Are they doing that before they leave, and then it switches back in? So there's some practical considerations of that as well.
And
then
also,
there's
sorry, I'm also bringing in new partners is a big
bringing
one
new partners
during
is
nesting.
huge,
That's
and
usually when it stops working.
absolutely, and making those decisions without having conversations, and suddenly people come around for a coffee, and then it becomes a bit of a longer period of time, and it is really destabilizing, not only for the children but emotionally for both parents that are trying to navigate this as well. And it can be quite a confusing time for children, and that's why, as I say, short term it can work. But they do need to understand as well what the future is going to look like, and so nesting long term can actually impact their ability to process what's happening to their with their family, and how that's going to look in the future, and how those arrangements might stand the test of time. So I think nesting is a good option. It's a particularly good option short term, and if you need to implement something that helps you with the transition. But I would always couple that with some form of written agreement about how that's going to work in practice.
Yeah, I agree. And I think nesting, as you say, it works well in the short term. Over time, it tends to fizzle away, especially as people meet new partners. But it also requires a degree of collaboration. And if we're tapping into domestic violence and real safety concerns, then it really isn't an option anymore, is it?
No, and that you've got an imbalance of power immediately in being able to make those arrangements standards, actually just from a practical point of view of actually putting them in place, but also making sure that they don't get abused, and that there isn't an abuse of that process in itself in terms of how that's managed. So it really would be very specific to couples that can work as amicably as possible together. There isn't high conflict or risk of any abuse or power imbalances. It is quite specific to circumstances, I would say.
Yeah, so I guess the point here is that there's really a lot of different options, and depending on your situation, one might be more suited than the other. There was one last question that I wanted to bring up, because it's another one that comes up a lot in this context, is people being concerned that if they move out just to protect their space, and start renting a flat, that in itself they should financially have to commit an environmental financial proceedings because of the status they have in the court to rent this property. How does that impact the treatment?
I think the court is very alive to the fact and that sometimes interim measures need to be put in place. Of course, it's going to be relevant what the financial resources are to meet separate accommodation. But I think, on balance, interim arrangements that help diffuse matters at home you're not going to be used as a stick to beat you with down the line. Generally speaking, it's about being practical, and it's about understanding what the future is going to look like. And actually, ultimately, this couple need to be able to live separately, and they are going to have to live separately. And how that's going to be afforded, or what the practical arrangements for that are in terms of their financial landscape, are going to be determined. So I think there's two things to say. One, if it helps you navigate this next step, making a decision to short-term rent is a positive thing, not a negative thing. It doesn't relinquish your rights to the family home. What happens with the family home is going to very much depend on the overall financial circumstances and the needs of your children, and how your housing needs are going to be met moving forward. And that's something to be looked at very separately to what the interim arrangements are going to be. And so no, and I think people should need to do things that are going to work for their family in the short term, and be as practical about those as possible.
I think that's a great tip. So I like to finish my podcast by asking my guests for their top 3 tips. So for somebody who's exactly in the kind of situation we're describing, where it's just becoming untenable to live together during the process of divorce, what would be your top 3 tips to them?
So my first tip would be early legal advice in terms of looking at what your options are. If from 2 perspectives. One, if we're looking at how do we navigate this next phase, and what practical arrangements can we help you put in place in order to do that? And that is very often very circumstance dependent. So I would say getting some early legal advice. If you are at all concerned about your safety or the safety of your children, that is absolutely essential to make sure that we're considering whether or not any protective orders need to be put in place. I think the second thing to think about is give yourself time in all these situations. It can feel like your world implodes when you start navigating divorce and separation. Everything feels a little bit worse sometimes than perhaps it is. And I'm not talking about the context of safety and well-being, but in generally living under the same roof when you're separating, everything feels so much more heightened. And just giving yourself a bit of time and better breathing space, and take that advice and get that support in place to then be able to think clearly about, okay, what's going to work for us in this short term?
Yeah.
What's going to, what can we practically do to help all of this work a little bit better? And I think my third tip is keep your lines of communication open as much as possible.
I like that.
And that is going to be very much, it is going to be very much dependent on the dynamics between you, but find a way of communicating that's going to work for you, even if it's just in the short term. If you feel that having direct conversations aren't going to work for you, think about whether you do that via a parenting app or via email. And touching on what I was talking about earlier in terms of not having big conversations at difficult times of day. So keeping those lines of communication open, but with boundaries in place to protect yourself in terms of having those conversations, and making them productive as possible, I think is really important, and something to really think about doing.
I like that last tip. I think it makes a lot of sense. And actually, in a lot of ways, coming to an agreement on these short-term solutions can set a really good precedent to, okay, we found solutions. It wasn't ideal and we both struggled, but we managed. And so that means we can do it as well with the big picture items. So it's a nice way as well of getting that under your belt.
I think so. And I think you often find people who can't talk necessarily immediately, and they do end up, say, perhaps doing it over a parenting app or doing it via email. Once things have diffused a bit, they can open those conversations up more directly. It just gives them that bit of time and reflective space to manage it in the best way possible, to then being able to move it forward. And that's something I often talk to people about in mediation. It's like, well, what works now? And then we can have a look about how that might shift once things have calmed down a bit and once there's a bit more certainty about what's happening. It's just about finding a channel that you can both work with, and keeping an open mind about how that might change itself as things move on.
Absolutely. Well, thank you so much, Emma. So many helpful tips. I'm going to put your email address in the notes for the in the section, the description of the episode, so people can contact you if they have any questions. Is there anything else you want to say before we wrap up?
I didn't think so, no, but thank you for having me.
Thanks for joining me. Take care, Emma.
Thank you.